published Unjustified Enrichment by Niall Whitty in the Stair Memorial Encyclopaedia reissue series. Appropriately, as we'll see, it came out on St. Andrew's Day last year, 30th November 2021. My name is Hector MacQueen, and it's my privilege and pleasure to chair this event, introduce the speakers to you, and conduct the Q&A sessions, which I hope we'll be able to fit in over the next couple of hours. Could I just briefly remind everyone of the usual housekeeping rules on these matters? Mute your microphones, and once the presentations are underway, it's helpful, I think, at least to some, if cameras are switched off, because apparently that can cause interference with the overall reception of the speaker. But if you participate in the Q&A, feel free to switch your cameras on and obviously your mics as you see fit. Now, the format of the afternoon is going to be as follows. We'll have two sessions, each just under an hour long, with a break between them of 5 to 10 minutes to rest the eyes, stretch the legs, etc. In the first hour, Niall Whitty himself will open the proceedings, to be followed by Helen Scott and Jacques du Plessis, and then we'll have some Q&A running up to the first interval. In the second hour, Sonja, Meier and Danie Visser will make their contributions, and we'll close with more Q&A. Now, I'll first introduce Niall to give a presentation which we've actually recorded in advance to make life a little bit easier for him. Niall worked in the Scottish Law Commission for many years before becoming a commissioner in his own right in 1994. And it was at the SLC that he began the research, which has culminated in this magnificent magnum opus. I just illustrate its thickness for your benefit if you haven't seen it already. Now, I've described it as more than a book on the Scots law of unjustified enrichment. It's an analysis of Scots private law, obligations and property from the perspective of unjustified enrichment. And as such, every Scots lawyer should be aware of it and read it at least in part. But although I know Niall is anxious above all to have an impact on Scots law, he is well known internationally as a deep thinker on unjustified enrichments generally. And our other speakers and participants today reflect the worldwide esteem in which his contribution and that of Scots law in this area are held. Now, by dint of sharing my screen, I hope to be able to give you Niall Whitty.
I must confess, I have been fascinated by the Scots law of unjustified enrichment for over 60 years. My first contact with it occurred in autumn 1961 in my first year at Edinburgh University Law Faculty. At that time, the English law of unjust enrichment, or restitution, with its imputed contract theory of quasi-contract and its coronation cases, rejecting restitution after frustration of contract, was held up to students in the civil law class as evidence that the English law of obligations, while rich in detail, was poor in principle. By contrast, Scots enrichment law, with its obediential obligation theory and Cantieri San Rocco case, was said to be much superior, as indeed in some respects it plainly was. In the next 3 decades, however, the condition and status of unjust enrichment in English law was completely transformed, where the Scots law, starved of research and the stimulus of comparative law, tended to stagnate and sometimes took wrong turnings. The reason was not so much complacency as the fact that the academic branch of the Scottish legal profession, while growing, was still relatively small and certainly overstretched. Probably more has been written on our enrichment law in the past 30 years than in the previous 300 years. In English law, unjust enrichment as a new source of obligation became, in Ernest Weinrib's words, the most dynamic of all areas of private law. Much of the credit for this is rightly attributed to the charismatic influence and intellectual brilliance of Peter Burks. In his 2 articles on Scots enrichment law in 1985, he made 2 extremely important contributions to its development. First, Burks argued that there should be one general principle against unjustified enrichment, which should apply throughout that branch of the law of obligations. He also defined its elements in a famous 4-point test. This teaching and test assisted the higher courts in 3 great cases in 1995 to 1998, Morgan Guarantee, Dollarland and Shilliday, to sweep away the novel divide introduced by the 2nd Division in Royal Bank of Scotland v. Watt in 1991 between restitution and repetition, supposedly based on equity on the one hand, and recompense, alone based on unjustified enrichment on the other. The general principle did not amalgamate the obligations of restitution, repetition and recompense, the 3 R's, which survive to this day as separate nominate obligations differentiated by their contact. But the principle impliedly recognized and affirmed their common legal purpose, namely the redress of unjustified enrichment. Second, Burks convinced the Scottish courts that the classification of unjustified enrichment should be by the cause of action. In other words, the reasons for reversing the enrichment, and not by the type of benefit received or restored. Only in that way would like cases be treated alike. However, Burke's original belief that the Scottish causes of action should be based on the English system of unjust factors was not accepted by the Scottish courts or the legal profession. It simply did not fit the Scottish primary sources. As Lord Cullen said, our law had developed in a different way. That was true not only of enrichment by transfer, but also of all the other Scottish categories of unjustified enrichment. Our rejection of unjust factors was matched by our acceptance of the civilian doctrine of absence of legal justification for retention of the enrichment. In Latin, sine causa retenendi. The main task then became how to classify these legal justifications. Now, in the 1990s, new channels of communication with continental European lawyers opened up, and old channels of communication with South African lawyers, which had been largely closed because of apartheid from the 1960s to 1990, were reopened. As a result, a near miracle happened. The revival and reinvigoration of our civilian tradition in the domain of unjustified enrichment. It resembled, in important respects, the new civilian revolution already taking place in Scottish property law. A study of Scottish advocates' links with Germany in the 19th century showed few signs of any direct impact of German law on the practice of the law in the Scottish courts. The same position seemed to be true of the rest of the 20th century. In the early 1990s, however, the position changed. At that time, one of my tasks at the Scottish Law Commission was to research the rule preventing recovery for error of law with a view to its abolition by statute. I found the law difficult to understand until I discovered a seminal article by Reinhard Zimmern in 1985 suggesting the adoption in South African enrichment law of the Wilbur von Keimerer typology. That hit the spot. I still remember the strong feeling of discovery and relief at finding the way forward for the Scots law. That typology, classifying the causes of action by the manner of the defendant's enrichment, influenced the Scottish Law Commission's publications, and its main features have been adopted, mutatis mutandis, by virtually all recent writers on Scots enrichment law. Its impact was and is fortified by in Scotland by a stream of scholarly articles by Robin Evans-Jones and his pupils and colleagues. His pioneering and authoritative two-volume Sully monograph of 2003 and 2013 is paralleled in South Africa by excellent monographs by Daniel Visser and Jacques du Plessis. The reception, however, is not complete until it receives judicial endorsement. It may be instructive to consider whether the Scottish reception of the Wilbur von Keimerer typology is consistent with Lord Rogers' scepticism about what could be learned from civilian systems and comparative law scholarship. Roughly speaking, he thought broad guidance was possible, but of limited value, because the devil is in the detail. The reception could certainly be regarded as broad guidance. Moreover, it did not involve importing detailed rules of German law. Rather, it involved classifying and organizing civilian and other compatible rules and concepts which were already embedded in our law. By the same token, I think borrowing Burke's system of autonomous unjust factors could not have worked well at any level, broad guidance or detail, in Scots law in this area, with its civilian origins and character. Surely scepticism should be directed against transplants from English law. Alas, Lord Roger in Shilliday praised Burke's articles of 1985 favouring unjust factors for Scots law, and never retracted his views even after Burke's conversion in 2003 to the civilian sine causa approach. This was inconsistent with the court's adoption of the condictiones in Morgan Guarantee and Shillity itself. The mixed messages are a recipe for uncertainty and muddle. Writing of the choice between unjust factors and absence of legal juristic reason, Professor Hector has observed that the required fit and explanatory reach of an approach depends to a large extent on the field of it has to cover in any given legal system. In English law, leading scholars have argued that the scope of unjust enrichment should be restricted to enrichment by transfer. They write of the overgeneralization and normative inadequacy of the existing English law. Their desire for a small enrichment law is consistent with the Supreme Court's decision in 2017 restricting the English law of unjust enrichment to direct enrichment by transfer and confining recovery of indirect enrichment, at least in transaction chains, to a limited list of recognized regimes. While some of these criticisms no doubt apply to Scots law, in Scotland, with few exceptions, there is no pressure to reduce the size of unjustified enrichment. Why the difference? One reason may be that, apart from some controversial recent growths, its scope is largely determined by the scope of the 3 R's as developed over 3 centuries. It is an old source of obligation. All of its main parts are needed and indispensable, with minor exceptions. There is no better home for them in our law of obligations. The Scots law, despite its defects and recent changes, is not a new, unduly expansive and unsettling category, uncertain of its place. Moreover, unjustified enrichment covers a significantly larger area in Scots law than in English law. The latter lacks the 2 imposed enrichment categories. Furthermore, much of recompense for interference in Scots law is in English law the domain of the strict liability proprietary torts. Abolition of recompense for enrichment by interference would leave a large gap in our law of obligations. Now, the help given to Scots law by civilian lawyers was direct in assisting us to develop our own sources, but also indirect by accomplishing or helping to accomplish the astonishing feat of undermining the credibility of the English system of unjust factors. As a working model in English law, its jurisdiction of origin, and a fortiori in Scots law. The effect of Burke's change of allegiance in 2003 from unjust factors to absence of juristic reasons has been traumatic throughout the common law world. It triggered what Lord Walker of Gessingthorpe called in 2006 a period of reappraisal, which seems to be still ongoing in 2022. I do, however, think that our position in Scotland is different. We need a period of consolidation, not reappraisal. If the Scottish academic consensus is right, our legal position, our legal system has already chosen its road through the enrichment forest, and we must now strive to make it work well. It is difficult to effect a major restructuring of the common law by judicial decisions. There is little or no desire for codification or legislation. A restatement backed by an advisory group of judges, practitioners and academics would be a different matter. In developing Scots enrichment law, many challenges lie ahead. I have referred to possible examples in the annex here too. No doubt there are many more.
I will endeavour now to introduce Helen Scott, who probably needs no introduction to most people in this audience. She currently holds a chair in the University of Oxford, but will shortly become the Regius Professor of Civil Law at the University of Cambridge, crossing one of academe's great divides, as they say. So, Helen, may I ask you to turn your camera on and address us on the subject of error in unjustified enrichment. It may perhaps be helpful if I say to people that in general the topics for the individual contributions that have been chosen are ones that you might say cut across private law. So error is obviously one of those topics. Illegality, which Jacques du Plessis will address after Helen has spoken, is another. But Helen, please come to the podium, as I see you are already, and let us see or hear what you have to say on that subject of error. Thank you.
Thank you, Hector. There's probably a word of explanation required at this point. We've just finished the BCL restitution seminar, the last one of the year, and I'm in one of the lecture theatres in the law faculty with Bill Swadling and Rob Stevens and some of the students as well, and that's why I'm standing at a podium. But as long as you can hear me, I realize the visuals are not particularly clear, but I'm hoping the sound is okay, so I'll go ahead on that basis. Right, well, thank you very much for the opportunity to speak. I'm going to plunge straight in to a few remarks on the condictio indebiti, on undue transfer under error. Now, like South African law, Scotland is the inheritor of an uncodified civilian tradition via its institutional writers, and in particular, it's inherited the cause of action that Justinian's compilers labeled the condictio indebiti. And since at least Hume, and like its South African counterpart, the Scottish condictio indebiti has been analysed as an expression of the principle against unjust enrichment. So it sits at the centre of the modern Scots law. Now, like Justinianic Roman law, Scots law requires that in order to succeed in the condictio indebiti, the pursuer must demonstrate that he conferred the benefit in question in the mistaken belief that it was due, when in fact it was not. And I'd like to take that simple proposition as my central theme, but I'm going to begin with 4 preliminary comparative points before I plunge in to the meat of the question. The first preliminary point I want to make is that the Scottish condictio indebiti is limited to cases of mistake, or rather error. So unlike its South African counterpart, it doesn't lie in cases involving compulsion, or as I've argued, the South African one does, incapacity. The first of these, at least, should be dealt with instead, so Professor Whitty argues, as an instance of the condictio sine causa specialis. On the other hand, the Scottish condictio indebiti is no longer limited to enrichment in the form of the transfer of goods or money, since Dollar Land and Schiller Day in 1998, the conditiones lie also in respect of services, and that's because they were disaggregated from repetition, claims in respect of money, and restitution, claims in respect of goods, which were forms of enrichment to which they had formerly been limited. Now, this disaggregation of causes of action from forms of enrichment hasn't yet occurred in South African law, where the condictio indebiti, like its Roman forerunner, remains limited to cases involving the transfer of goods or money. And this seems to be one respect in which Scottish law is clearly pulled ahead of South African law. And here, Professor Whitty elegantly acknowledges the formative influence on Scots law of Peter Burke's. The third preliminary point is that, like English and South African law, and indeed many other jurisdictions, Scots law no longer recognizes the rule that mistake of law precludes a recovery. This is a development that occurred in Morgan Guarantee Trust versus Lothian Regional Council in 1995, which was, like Kleinwort Benson and Lincoln in 1999, a swaps case. And in his account of this development, Professor Whitty carefully examines the civilian history of the mistake of law rule and its incarnations in modern civil law systems, as well as its treatment at the hands of the law commissions of Scotland and England. And his account of the rejection of a defense of statutory bar against the reopening of payment transactions concluded on the faith of a settled view of the law, subsequently changed by judicial decisions, seems to me particularly salient in light of subsequent decisions in Deutsche Morgan Grenfell and now FRI. My final preliminary point is that, like English law, but unlike South African law, Scottish law has successfully resisted the temptation to resist recovery to cases where the pursuer's mistake can be said to be excusable. Now, in the South African case of Willis Faber Enthoven and Receiver of Revenue in 1992, it was said that in determining whether the plaintiff's mistake is excusable, much will depend on the relationship between the parties, on the conduct of the defendant, who may or may not have been aware that there was no debitum, and whose conduct may or may not have contributed to the plaintiff's decision to pay, and on the plaintiff's state of mind and the culpability of his ignorance in making the payment. Now, this represents the consolidation of at least a century's worth of South African authority and the convergence of a number of different strands in the deeper civilian tradition. It's still good law in South Africa. And it's also, as it seemed to me in 2007, in an article which Professor Whitty generously acknowledges and seems to me still wrong, not least because I think it rests on a flawed conception of the role of mistake in the context of unjust enrichment claims. Now, Scottish law also showed signs of developing a positive requirement of excusable mistake, and we can see this in a case like Wilson and McClellan versus Sinclair in 1830. And ironically, this is a decision of Lord Brougham that relied principally on English authority. But after Balfour versus Smith and Logan in 1877, the Scots courts turned away from such a positive requirement, and they preferred instead the newer English law expressed in Kelly and Solari in 1841, that any mistake would suffice if only it was genuine. To the extent that excusable mistake did feature in the Scottish court's reasoning, it was cast as a defense, an equitable defense to the condictio, and this view was decisively accepted in Morgan Guarantee. And again, that seems to be a clearly preferable position to the one that prevails in South African law. So those were my 4 preliminary points. I'd like to now return to the principal point, which is the requirement of mistake, or rather error itself. Now, as Professor Whitty emphasizes, as in both English and South African law, in Scots law, in the context of the paradigm case or paradigm claim to recover a mistaken payment, it's for the pursuer to prove that he paid in error. And again, this appears clearly from the Morgan Guarantee case in 1995, but as Professor Whitty shows, it's been firmly established in Scots law since the time of the institutional writers. On the other hand, as was also held in Morgan, it is of the essence of the condictio indebiti that the payment or other transfer that the pursuer made was not due. And similarly, Lord Hope said, it is the fact that the sum was not due that provides the ground for repetition on the principle of unjustified enrichment. And as Professor Whitty says, quoting Sonja Meier, comparative law shows that the difference between error in civil law systems and mistake in English law is that in civil law systems, error is only a secondary element in addition to the absence of basis. So it seems that although it's well established as a matter of authority, error is a conceptual interloper in Scottish law insofar as that system is committed to a civilian absence of basis approach. More recently, comparative insights like those of Professor Meier and Reinhard Zimmermann have been supplemented by theoretical critique. And as Rob Stevens has argued, being wholly claimant or pursuer-sided, error cannot provide a valid reason for restitution. A defect in the knowledge of the pursuer cannot constitute the right sort of reason for imposing a restitutionary duty on the defender because it does not apply to him. So we have, it seems to me, a double problem when we try to account for the fact that error remains an essential element of the contemporary Scottish condictio indebiti. Now, in solving this problem, it's important to emphasize that Scots error is not the same as English mistake. Since Barclays Bank and Sims, it's been established in English law that the claimant's mistake need not relate to his liability to pay in order to found restitution. It's enough that it caused the payment. But as Professor Whitty shows, error in the context of the Scottish condictio indebiti is confined to liability mistakes. And this means that it acts, at least in part, as a proxy for the absence of any valid obligation underlying the transfer. But given that the pursuer must also demonstrate that the transfer in question was not due, in truth, such a proxy is superfluous. If the only function of error is to demonstrate the lack of an underlying obligation, then it seems as if the Scottish condictio indebiti is overdetermined. More promising, it seems to me, is the argument that error serves as a technique for vitiating the pursuer's consent to the unjustified enrichment of the defender. So according to Professor Stevens, mistake in the context of the claim in Kelly and Solari serves to anticipate and preemptively defeat what would otherwise serve as a justificatory defense, insofar as it negates the defendant's duty to make restitution. And it seems to me that this is precisely the same point that Professor Whitty makes following the court in Morgan Guarantee, when he emphasizes that the function of error in the context of the Scottish condictio indebiti is to show that the pursuer conferred the benefit without any donative intent. And indeed, he takes the same view of improper compulsion cases and indeed of willage claims. In all these cases, he says that the presence of error or illegitimate pressure or the particular relationship between the pursuer as taxpayer and the defender as revenue serves to show the absence of any donative intent on the part of the pursuer. It's the conferral of a benefit that was not due, coupled with the absence of any such intention, that justifies recovery in all these cases. And that's true despite the fact that they're not analysed as instances of condictio indebiti, at least in Scottish law. But it seems to me that there are still three objections to this view. The first one, which I'll sketch out briefly, is this. If indeed the purpose of error in the Scottish condictio indebiti is to show the absence of donative intent, if it were the case, I think Scots law would take a firmer position on doubt. That is, I think there would be clearer evidence from the cases that doubt as to his indebtedness on the part of the pursuer is sufficient to substantiate his claim. And one can make the same point about payment under protest. If the only role of error was to demonstrate the absence of donative intent, well, then unilateral protest on the part of the pursuer would surely be adequate to establish this, whereas in fact it seems that it's not. So that was the first objection. The second one, which Professor Whitty discusses and which he attributes to Robin Evans-Jones, Professor Robin Evans-Jones and Professor Philip Hellberger, is that this view of error offends against the presumption against gift. In other words, people who confer benefits on other people do not typically do that with donative intent, and therefore it's highly artificial for the law to presume such an intention from the mere fact of deliberate conferral. So it follows that instead of the pursuer proving error, the defender should be required to prove that the transfer was indeed a gift. It seems to me that it might be offered in reply that there are good practical reasons for placing the burden of proof on the pursuer, because it's he who's best placed to establish his own mental state. But that, as I say, constitutes a second objection to Professor Whitty and Professor Stevens' construction of error. That still leaves a third weightier objection, and I'll try and sketch that out relatively briefly. If the defender has punched the pursuer on the nose and the pursuer can be shown to have consented to the punch, the pursuer's consent is a reason of the right kind to found a justification, a justificatory defense. It's a reason that applies to both the defender and the pursuer. But in the context of an erroneous payment, consent or donative intent, like error itself, is wholly pursuer-sided. What the claimant in Kelly and Solari consented to, if indeed they did consent, was not a prima facie breach of duty by the defendant, like in the case of the punch, but what they consented to was their own act, which is the payment to the widow Solari of an amount not due. And that's not a reason that can apply to the defender. So it doesn't seem to me that it's capable of defeating the pursuer's claim by justifying the defender's receipt of any undue payment. It's no good to reply that, at least in the civil law, donation is a contract, which is surely a bilateral reason par excellence, that in truth, donative intent is a form of legal ground. So it's really a denial rather than an offence. And that's because there's simply no requirement in Scottish law, or indeed in South African or English law, that the defender be aware of the pursuer's donative intent or accept his offer of donation in order for such consent to be effective. Indeed, in very many cases, the defender will be oblivious to the pursuer's mental state. So in the context of payments under error, consent doesn't seem to entail a bilateral reason of the right kind to defeat the defendant's primary duty to restore. And so error can't, after all, be understood as a factor that invalidates a justificatory defense of consent or donative intent. So the question remains, how do we understand it? And in fact, I think the solution to this problem lies in an idea to which Professor Whitty himself refers in the opening paragraph of his treatment of the condictio indemnity, where he says that the purpose of the transfer must be to satisfy an obligation on the part of the transferor that turns out not to be due. Now, it can reasonably be assumed that payments and other kinds of deliberate conferral are made in discharge of liability, because this is by far their most common purpose in practice. And in the same way, it can reasonably be assumed that payments that are unsupported by a legal ground have been made for a purpose that has failed. Now, in the context of the German Leistungskondition, so I understand it, both the likely purpose of the benefit, that's the discharge of liability, and its failure are assumed in the claimant's favor, as long as the transfer in question is unsupported by any objective legal ground. But Scots law, in common with English law and South African law, makes neither of these assumptions. Instead, proof of a liability mistake by the pursuer serves to demonstrate the purpose of the transfer, as well as its failure. To spell the point out more fully, proof of a liability mistake on the part of the pursuer demonstrates both that this purpose, in making the transfer was the discharge of liability, and that such a purpose has objectively failed. Because most payments are made in discharge of liability, the defender himself can and should assume such a purpose on the part of the pursuer. The outward meaning of his act in accepting the payment is that its retention is conditional on the achievement of that purpose. So, unlike mistake or error, the failure of the purpose of the transfer constitutes the right kind of reason for restitution, and that's because it applies to both the pursuer and the defender. Now, the analysis that I've briefly set out here, it seems to me to explain the prominence of error in Scots law. Professor Whitty is right. Error is not an unjust factor in the sense that Professor Burks understood the term, but neither is it merely a technique for displacing donative intent. In fact, error provides an elegant, economical account of the pursuer's cause of action in condictio indebiti cases. It is an efficient heuristic for determining the failure of the purpose of the transfer. It's also easily accommodated to the reality of an adversarial system like Scotland's, in which the burden of proving all the elements of his cause of action falls on the pursuer. And it's these features that explain the observable phenomena. The depositive requirement of mistake or error has emerged in a variety of contexts, and that it continues to flourish despite sustained academic criticism. That concludes everything I wanted to say about the substance of Professor Whitty's treatment of error. I'm sorry that I've spoken for rather longer than 15 minutes, but I would like to close by saying that I am both in awe of the scale of Professor Whitty's achievement in completing the project and excited to have such a rich seam to mine for future work on unjustified enrichment. I have for many years been the recipient of his gentle support and charming encouragement, and I'm delighted to have been able to offer these ideas today by way of a tribute. Thank you very much, Hector.
Yes, thank you, Helen. Thank you very much indeed for an extremely interesting and thought-provoking contribution to our seminar. I'm going to move straight on in the interests of time to Jacques du Plessis on error, sorry, on illegality. It's not being a good afternoon for me, really. But Jacques, would you like to take the floor?
I would gladly respond to Helen's views on error and its support in our case law, but that's not what I've been asked to do. So let me, without any further ado, proceed to the paper, which is titled Comparative Observations on the Consequences of Illegality. Few topics in contract and enrichment law are more confusing than illegality. We do not know what illegality means, we do not know why it arises, and we do not know what its consequences should be. We seek our refuge in rules and exceptions and discretions, but in a bewildering variety of ways. And yet, all is not lost. We now have a better understanding than ever before of how we reached this position and how we could extricate ourselves from it. In the context of Scots law, Niall Whitty's highly detailed historical and comparative treatment of this topic in the Stair Memorial Encyclopaedia has made a major contribution to this end. It far exceeds what one would expect from the typical encyclopedic expositions of basic principles. Although we all know that Niall deeply values principles and doctrines, especially as revealed by the civil law roots of Scots law, his pragmatic exposition pays particular attention to developments in the English common law, which may prove decisive for the future of Scots law. So one may forgive Niall for having more citations to Andrew Burroughs in this chapter, at least, than to Reinhard Zimmermann. But more about that later. I'll skip the bit about the meaning of illegality. We don't have time. And start off with the consequences of illegality. Here, Niall points out that the current position in Scots law is unsatisfactory. An obvious example is the baffling distinction that Gloag and others have drawn between, on the one hand, agreements which the law will not allow to operate as contracts or contracts merely declared by statute to be void, and on the other hand, contracts which are contrary to the law or which are illegal. As they say, when the law starts behaving like this, you know that it is in trouble. Conceptually, it is not clear why one would want to differentiate between some cases giving rise to voidness and some cases involving illegality. A more helpful approach, which Niall also favors, is first to determine whether there is illegality and then to determine its consequences, which could include voidness as well as other consequences such as voidability and an enforceability. Now, of course, aware that in various jurisdictions these terms bear various meanings. But this, of course, creates a further challenge, namely to understand what these consequences exactly are and why the law could attach them to specific instances of illegality. Let us briefly consider why one would want to impose the consequence of voidness as opposed to unenforceability. Some seem to believe that in more serious cases of illegality, the supposedly harsher consequence of voidness is more appropriate than that of unenforceability. So in the latter case, you still have obligations, they're just not enforceable. But would voidness necessarily be the harsher consequence? Assume that one party performed in full and that the other party performed nothing. In such a case, the consequence of validity but unenforceability may be much harsher on the performing party than the consequence of voidness. This is because a valid but unenforceable contract provides a legal ground for retaining enrichment. So the performing party under such a contract can neither claim enforcement nor seek restitution, whereas the performing party under a void contract is in a better position, since it could at least potentially claim restitution. But even if we understand the consequences of illegality a bit better, we still need greater clarity on how to choose between these consequences. And in this regard, both South African and Scots law may, I suggest, benefit from adopting a stronger comparative perspective. Comparative analyses reveal various factors that could explain why different situations of illegality have different consequences. Examples of such factors include not subverting the purpose of the infringed rule, protecting certain categories of persons, not subjecting a person to multiple sanctions, as well as the seriousness of the infringement and whether the infringement was intentional. Factors like these already influence the interpretation of statutes to determine their effects, but they may also guide the determinations under our common law, and that I mean South African common law and Scots law, common law, of the consequences that are attached to some illegal contracts. For present purposes, the most important of these is the duties of restitution that could arise from voidness. And it is to that which I will, consequence that I will now turn. It is an unfortunate characteristic of processes of reception that a donor legal system sometimes influences a recipient system to adopt one of its rules, only for the donor subsequently to realize the error of its ways and to change its laws, thereby leaving the poor recipient with a bad rule and only the hope of ridding itself of it one day. This has happened in Scots law. Traditionally, it followed civil law principles, which in cases of illegality allowed restitution subject to a turpitude bar. However, for more than a century, some Scottish courts and writers have supported the traditional English approach of denying recovery in cases of illegality unless certain rule-based exceptions, such as the problematic no reliance on illegality rule, applied. As you are undoubtedly aware, in 2016, English law changed course in Patel versus Mercer and adopted an approach closer to the civil law position, inasmuch as its point of departure in cases of illegality is now to award restitution, but subject to a judicial discretion. That English law was in need of change has been widely appreciated, but where does Patel leave Scots law? Niall considers three routes that it could follow. A particularly important aspect of Niall's analysis of these views is that he highlights how they differ in regard to the significance that they attach to whether the party seeking restitution was blameworthy or was tainted by turpitude. First, there's the view of Robin Evans-Jones that greater personal blameworthiness or turpitude on the side of the party seeking restitution automatically bars relief. However, as Niall points out, inter alia, rather uncharacteristically invoking Peter Burke's, a more nuanced approach may be preferable. It is not apparent why the pursuer's relative blameworthiness should be so decisive in determining whether to award restitution. This criticism is also shared by Hector, MacQueen, and Joe Thompson. They regard the moral turpitude of the parties as only one of the factors that may warrant a denial of restitution. However, Niall is concerned that their approach may still accord too much significance to the incidence of turpitude and neglect other factors such as the importance of promoting the policy behind the infringed norm. Thirdly, Niall refers to South African law. After initially following the reliance rule of English law, South African law as far back as 1939 returned to its civil law roots. This entails that an enrichment claim is available if a contract is void due to illegality, but that the par delictum rule bars restitution if the plaintiff is tainted by turpitude, which essentially means morally dishonorable conduct. However, South African law since then has added the qualification that the application of the par delictum rule is subject to an equitable judicial discretion. I used to support this South African approach, but I'm not so sure about it anymore. It just seems so convoluted. You have a prima facie right to restitution. Then you prima facie lose it due to a taint of illegality. Then the courts have a discretion to award restitution in any event. A Patel-style approach just seems to me more simple and more direct. You have a prima facie right of restitution subject to a discretion. Writing in the context of German law, Jacob Gleim has argued in favor of the German version of the par delictum rule, and in German law there are now specific rules relating to the exceptions. He's argued in favor of the German version of the par delictum rule that it has the benefit of, in effect, placing the tainted plaintiff on the back foot when arguing whether restitution should be allowed. And this is supposedly then desirable because the plaintiff has, as he said, disregarded the legal order. But prima facie denying restitution to a tainted transferor just seems to me to be unduly judgmental. Whether the transferor engaged in dishonorable conduct or is tainted by turpitude may indeed be a weighty factor in awarding restitution, but it is not apparent why this factor should be elevated to such prominence. This seems to reflect an excessively moralistic view of the sanctity of the corridors of the courts, which seems somewhat out of place in modern times. While Niall has some sympathy for the South African approach, he ultimately prefers the structured judicial discretion introduced in Patel. In the context of Scots law, he is particularly motivated by the pragmatic consideration that many statutes apply on both sides of the border. This, it seems, would render some uniformity desirable. But, as I hope to have indicated above, the Patel-style approach of combining a prima facie right to restitution with a judicial discretion may be in any event preferable on other grounds. However, the devil is in the detail. Supporting the Patel approach as a point of departure does not imply that Scots law or South African law has to adopt the so-called trio of considerations that the court in Patel resorted to in exercising its structured discretion. Our systems all clearly have had enough of rule-based approaches and are willing to take the risks of uncertainty, which is the price that one has to pay for a more flexible discretionary approach. But to reduce uncertainty, certain factors could play an important guiding role. And in this regard, a comparative perspective reveals various lists of factors or considerations that could potentially influence exercising such a discretion. It is like in the Mikado. Everybody has got a little list. Apart from the Patel list, there's a Burroughs list. Niall has his own intriguing list. I, for better or worse, have made a list for South African law, and there are also lists in the model instruments. It would be hardly possible to evaluate these lists here. Suffice it to say that the factors that they contain often overlap or hide underlying factors. And it may be that, as Sonja Meier has suggested, we ultimately have two main categories of factors. Firstly, the factors relating to the character of the rule that has been infringed, especially the rule's purpose, what groups of persons it's supposed to protect. And secondly, those factors that relate to the particular infringement, for example, the knowledge of the parties. But these investigations may be left for another day. For the moment, I would like to shift the focus from determining whether a claim of restitution should be awarded to determining how much restitution should be awarded, i.e. to quantifying these enrichment claims. Let us consider the two major Scottish cases of Cuthbertson and Jamieson. Cuthbertson dealt with the sale of potatoes by a measure not allowed by statute. The seller was denied enforcement, but was nonetheless awarded the market price of the potatoes. But awarding the seller such a claim may subvert the purpose of the statute. If the market price corresponds with the contract price, the seller effectively receives payment, as if the contract using the wrong measure was, for all intents and purposes, valid. Jamieson in turn concerned a claim for payment for some minor building works conducted without a license. Here, the purpose of the statute, namely protecting the interests of the state, was regarded as so important that the court veered to the other extreme of not awarding the builder any restitution at all. To my mind, both these cases focus too much on whether restitution should be awarded and not sufficiently on how it should be quantified. In cases of illegality, the double cap or double ceiling rule governs the quantification. And this rule could have prevented the plaintiff from claiming its profits. This means that the Jameson enrichment claim could only cover the builder's out-of-pocket expenditures in performing the works. It can be argued that depriving the builder of his profit already sufficiently serves the purpose of preventing the invalidating provision from being subverted. It is unnecessary to deny the builder his enrichment claim in its entirety. But there may even be cases where the double cap rule has an insufficient limiting effect. It might even be that the quantum of enrichment claims needs to be reduced even further, beyond depriving a party of the profits. This may be necessary because of the seriousness of the infringement or to deter future violations. In effect, the court should have a discretion, and this is now a proposal I make, it's not the law, but they should have a discretion as to quantum, but clearly not an unfettered one. The court may well be guided by similar factors to those that influence the determination whether a claim should be awarded. So these are familiar factors that I've referred to earlier. I readily concede that neither Scots law nor South African law traditionally recognize such a discretionary approach to the quantification of enrichment liability, but it seems to me that it could contribute to a more nuanced resolution of the illegality cases. I might just add that in our law, actually, when it comes to awarding restitutio in integrum, when a contract has failed due to improperly obtained consent, there are elements of judicial discretion in quantifying the claim. So it's not entirely revolutionary. In any event, it is time for me to conclude. And I'm now going to skip, and I'm sure there will be lots of clapping of hands and cheers, that I'm not going to deal with the issue of illegality and the condictiones and which particular condictio should apply in our systems when there are situations of illegality, but I would gladly deal with questions in that regard. So it is time to conclude and to return to the question of the restitutionary consequences of illegality. We have seen that Niall favors the civil law and Cuthbertson route of recognizing a prima facie right of recovery, but that he regards it as preferable to qualify this right with a Patel-style structured discretion rather than with the traditional civil law defenses that focus so strongly on the turpitude of the transferor. I think Niall's pragmatic approach represents the best of what can be achieved in mixed systems through deep and creative reflection. As we have seen, Niall's pragmatism is inspired by the need for uniformity given the application of many enactments across the border. However, I've argued that it may in any event be the preferable route in other legal systems, such as South African law, where the considerations of uniformity do not apply. I would just like to see such development being accompanied by the following. One, greater attention to the factors that influence a finding of voidness, voidability, or unenforceability as consequences of illegality. Two, explicit recognition that a finding of voidness is essential to trigger enrichment liability. Three, greater clarity on the link between illegality and the various condictiones, the topic that we did not touch on. And four, greater attention to how the quantum of enrichment claims arising from illegality is to be determined. Thanks for the invitation, Hector, and over to you.
Thank you very much for the contribution, Jacques. Very, very interesting. And again, like Helen's thought-provoking response to Niall's writings on this in the encyclopedia. Now, in terms of time, we've reached the point at which I was going to give the participants a little break. So I will begin, and I will introduce Sonja Meier, professor at Freiburg, who's possibly had the biggest impact on English law of any German professor, at least in the field of the law of unjust enrichment. But in thinking who to invite to contribute to this seminar, I thought of Sonja chiefly because of her Wilson lecture in Edinburgh a few years ago, where she discussed in a very interesting way the relationship between unjustified enrichment and contract law, and proposed a whole new way of thinking about it. And I'd like to invite her now to step forward to her microphone and share with us what her position on this is now and how she sees Niall's contribution to that particular debate. Sonja, over to you.
Thank you, Hector. Hello, Niall, and hello, everybody. In his presentation, which you didn't see, Niall had said that in developing Scots enrichment law, many challenges lie ahead. The list of examples he gave was not meant to be exhaustive. One particular challenge he did not mention was the legal regime for unwinding failed contracts. In his book, Niall gives us a particular clear and lucid presentation of the many problems that Scottish law faces in this regard, and I can only point to some of them. In his chapter on void contracts, Niall discusses the relationship between the condictio in debiti and the condictio sine causa. In substance, the problem seems to be whether error is required, and if so, who bears the burden of proof, already mentioned by Helen. Today, most commentators assume that the condictio in debiti of Scots law requires error, but that if no error was made, a condictio sine causa may be available, at least in some cases. The question of the error requirement is in turn closely connected with the question whether a fully executed void contract can and should be unwound, which Niall also discusses in his book. Both of these questions, whether error is required and whether there should be recovery after full execution, only arise in the context of void contracts. In cases of frustration and breach, the contract is by definition never fully executed, which is exactly why the performances already rendered can be recovered. Avoidable contract, by contrast, can be avoided, and performances can be claimed back even after full execution, since the defect of consent is so fundamental that the exchange of performances cannot stand. So, in cases of void contracts, the question is whether the reason for the voidness is so compelling that it requires the unwinding of performances, irrespective of whether the contract has been fully performed and irrespective of whether the transferor knew that the contract was void. An example may be the recovery of a performance by a corporation acting under an ultra-virus contract, which should arguably not be excluded by the mere fact that its representatives knew that the contract was invalid. It may be different where only the other party seeks recovery, as was the case in Morgan Guarantee. Here it could be argued that the other party needs no protection if it knew that the contract was void and the contract was fully executed. Where the contract is only void by reason of a mere lack of form, legal systems often do not allow recovery by a transferor who knew that the contract is void, except where the expected counterperformance by the other party does not materialize, in which case the condictio causa data causa non secuta can be used. The unwinding of this kind of void contracts is thus excluded where there is no mistake and the other party has performed or is at least ready and willing to perform. It seems therefore that there are stronger and weaker reasons for the voidness of a contract, and that every legal system faces the task of distinguishing between these reasons, between these two classes of reasons, and developing appropriate criteria for classifying them. If the role of the error requirement is to negative an intention of donation, as has been suggested by Niall, but questioned by Helen, a possible test in Scottish law might be to ask whether a genuine donation would be legally upheld in the case at issue. A donation would be upheld in cases of contracts merely lacking the required form, but arguably not where a corporation acts ultra vires. Another major problem discussed by Niall is whether the recovery of performances under a failed contract should be based on the law of contract or on the law of unjustified enrichment. Comparative experience shows that most legal systems use contract law in some cases and enrichment law in other cases, without there being a consensus as to what type of law to apply in which situations. As Niall's account shows, the problem is of particular relevance in Scottish law. In case of void contracts, recovery is based on unjustified enrichment, either on the condictio indebiti or on the condictio sine causa. Contractual claims seem to be excluded, since there has never been a valid contract. Conversely, where the contract is not void, but merely voidable for defects of consent, recovery is called restitutio in integrum and is generally regarded as a contractual remedy. One reason for this seems to be that rescission for defective consent itself is perceived as a contractual remedy, and rescission requires that restitutio in integrum be possible. Where the contract is frustrated, recovery is based on unjustified enrichment. In Cantiere San Rocco, the House of Lords applied the condictio causa data causa non secuta. And although there seems to be consensus that this was somehow incorrect, both historically and systematically, the case law seems to be too settled to be called in question now. Lastly, where the contract is rescinded for material breach, it is not even clear whether the aggrieved party can recover its performance at all, in addition or in lieu of its damages claim. If recovery is possible, it is not clear whether this claim is based on unjustified enrichment or, this seems to be the majority view today, on contract law. It should be clear by now that the different solutions cannot be explained by conceptual arguments like there is no contract, so it must be unjustified enrichment, or there was at least a valid contract at one time, so the basis of recovery must be contractual. In all cases of failed contracts, voidness, avoidance, frustration, termination, the specific contractual obligation to perform has either never existed or has ceased to exist. So it is in principle always possible to apply the law of unjustified enrichment in the shape of the condictio indebiti, sine causa, or ob causam finitam. However, the converse is also true. Even in cases of void contracts, it seems to be no contradiction in terms to base the claim for recovery on contract. After all, contract law determines that the specific contract is void. So why should contract law not decree that a performance rendered under this void contract has to be returned? So it is not conceptual reasons, but different results that could justify a classification of a claim as either contractual or arising in unjustified enrichment. In Niall's account, we find three major arguments, all of them inclining towards a contractual classification. The first is that unjustified enrichment implies an application of the defenses of change of position and balance of equities. These defenses can exclude recovery insofar as the defender is no longer enriched. Several commentators, among them Whitty, argue that a defender who received a contractual performance should not be allowed to raise a defense regarding losses or expenses that did not benefit the pursuer. Take the case of a sale of a car. If the buyer is able to recover the purchase price he has paid, he should also be subject to a restitution claim regarding the car, even if the car was destroyed in an accident. This means that the buyer should not be able to argue that he's no longer enriched. After all, he had control over the car and should thus bear the risk of its loss. This argument has been made both where the contract is void and where the buyer has terminated the contract for breach in the form of defects of the car. Basing recovery on contract law thus has the advantage that the defense of loss of enrichment can be avoided. On the other hand, it seems also possible to modify or to just not apply the defense in unjustified enrichment. But why should one want to classify the claim as a claim in unjustified enrichment if the defense of loss of enrichment is not applied or is excluded? Well, it could be argued that there are also other areas in unjustified enrichment where the defense should play no role, and that at least parts of the law of unjustified enrichment are about undoing transfers, not about taking away existing enrichments. Secondly, the contract sealing, where a party renders a performance that is not money and then terminates the contract for the breach of the other party, it should be able to claim recompense for its performance. There are good reasons for the view that such a claim should be limited by the amount the other party had agreed to pay for it. Does this mean that the recompense claim has to be based on contract? Or is such a contract sealing also possible within the law of unjustified enrichment? It could be argued that the defender was not, in this case, It could be argued that the defender was not enriched by the market value of the performance since he was not prepared to pay more than the contract price. However, according to Niall, it is not clear whether the theory of subjective devaluation is accepted in Scots law. He prefers the explanation that the enrichment of the defender in excess of the contract price is justified by a legal cause, namely the contract, which, despite the termination, survives as regards the valuation of benefits. But can this argument also be used in cases of void or avoided contracts? Or should there be no contract sealing when the contract is invalid? Again, I would argue that it depends on the reason why the contract is invalid. If the reason for the invalidity has nothing to do with the valuation of the pursuer's performance by the parties, recompense is arguably restricted to the contract price as a result of this valuation. The claim can nevertheless be classified as a claim in unjustified enrichment because choices of the parties have to be respected, not only in contract law, but also in the law of unjustified enrichment. Generally, the law of unjustified enrichment is accused of lacking sophistication with respect to its instruments. This is particularly apparent in the third example, the frustrated contract. The rules of unjustified enrichment allow recovery of performances that benefited the other party, but it is not even clear whether the expenses incurred by the other party can be taken into account. There is much to be said in favor of a general legal regime that distributes the losses among the parties. This seems to require a contractual solution. The instruments of unjustified enrichment seem to lack the necessary fine-tuning. However, it can be argued that the problem of frustrated contracts does not lie in unjustified enrichment law, but rather in contract law, namely in the proposition that a contract necessarily comes to an end in case of frustration. This view is firmly entrenched in English law, but it seems also to be dominant in Scots law. However, a modification or adaptation of the contract, well known in other legal systems, is often a better instrument to distribute losses among the parties than a termination of the contract. This is indeed a matter for contract law to deal with. What happens to the contract in cases of frustration? Since no party was at fault, should losses be distributed by way of an equitable adjustment, as has been proposed by Hector and other authors? And if a loss distributing regime is accepted for cases of frustration, why should it not be applied in cases of void contracts, where no party was at fault either? And if losses can be distributed in cases of void contracts, is this contract law? My point is this: contract law has to determine whether a particular obligation is binding or whether it ceases to exist. Recovery itself can nevertheless be based on the law of unjustified enrichment. On the other hand, I would submit that in all cases of failed contracts, the claim for recovery can as well be based on contract law. A contractual claim does not require a breach of contract by the defender. Therefore, even recovery by the contract breaker can be based on contract law, as is done, for instance, in German law. The principle of mutuality of performances explains why rescission for breach is possible. Recovery after rescission can then be explained just by the rescission itself, and so be available to both parties. In the end, I think it does not matter whether recovery is based on contract or unjustified enrichment, as long as like cases are treated alike. But of course, Scottish law, like other legal systems, has to make a choice. Niall's book will be a valuable and in the long run, indispensable tool in helping to further develop Scottish law. Thank you very much.
Thank you, Sonja. Very interesting and very thoughtful. I hope people have noticed that there may be a contrast between some of the things that you said just now and some of the things that Jacques du Plessis said immediately before the break, and also obviously, as you mentioned in the course of your talk, differences from the perspective offered by Helen. So the questions, I hope, are beginning to line up. But before I open the meeting to the floor, our last speaker is Danie Visser, a long time friend of Niall's. I'm not sure that I didn't first meet Danie because of Niall myself, but certainly there's been an important link there, which is apparent in the Stair reissue. So it's a great pleasure to invite Danie to be the last contributor to the seminar before we open up to question and answer. Danie, the floor is yours.
Thank you very much, Hector. Good afternoon, Niall, and good afternoon, everyone else. It is with great pleasure and gratitude that I participate in the celebration of Niall's magnificent achievement, because Niall has been, as Hector has indicated now, for almost 30 years, to me, a teacher, a critic, and above all, a friend. And he's been incredibly valuable in each of these roles. So I've been asked today to say a few things about my view on the differences between the common law and the civil law approaches to unjustified enrichment, and on an approach that I have suggested for South African law, which I've called the third way. Now, as is well known, more than well known, the common law approach to the element of unjustness has always been anchored in the question whether there is a positive reason an unjust factor or a restitution ground that renders restitution, retention of the benefit by the defendant unjust. While, on the other hand, the civilian approach has emphasized the notion of the absence of basis in deciding on the unjustifiedness of the enrichment. What I have called the third way is an approach that recognizes the importance of the role of reasons, alongside the notion of absence of legal ground, in answering the question why a particular instance should be branded as amounting to unjustified enrichment. Now, Jacques du Plessis has described Niall's warnings against the dangers of this approach in terms of Laocoon's warnings about the Trojan horse. While I must say, on the other hand, I feel rather like Cassandra, trying to tell the truth, but like her, doomed by Apollo not to be believed. I will argue this afternoon that both Niall and I should be believed. Now, I want to emphasize that in advocating for restitutionary reasons to be given their rightful place in civilian systems, I'm not suggesting a simple takeover of the English unjust factors as they have been developed by the English courts and the courts in the other common law jurisdictions. These unjust factors have been developed over a long time in the case law and are imbricated in a very specific way in the structure of the common law and depend for their full understanding on that structure. So rather like Teun van der Linden, who proposes a similar approach for the law of the Netherlands, I'm interested in the positive reasons as a means alongside the absence of legal ground to demarcate and contain enrichment liability. In other words, I'm interested in the conceptual idea behind unjust factors, not in introducing the specific unjust factors of English law. If those factors were to be introduced, to use a favorite phrase of Niall's, spatchcocked onto a civilian system, that wouldn't be a happy outcome. Now, some time ago, Sonja said to me in regard to my notion of the third way, she said, it's not a third way. What you describe is what civilian systems do. And I think she's right. But I think my original reason for calling it the third way was to signify a third way of representing what happens and should happen in both civil and common law systems, rather than the repeated dichotomous description which conveys the idea of a necessity of a choice between without legal ground and reasons for restitution. And just a short word about terminology as well. When I speak about absence of legal ground here, I don't mean absence of legal ground in the broad sense, in the sense that it is often quite legitimately used to indicate the outcome of taking into account everything that is relevant to determining whether an enrichment is being unjustifiably retained. Rather, I have in mind here today the absence of causa in a technical sense, because that is the meaning that is relevant to the debate about absence of legal ground on the one hand and reasons for restitutions on the other. So I want to begin with a quote from Walter Wilberg. Now, translated, he says, absence of legal ground determines unjustified enrichment only imperfectly. And then he goes on to say that both enrichment by transfer and enrichment in other ways have their own criteria. In the case of the Leistungskondition, the relevant criterion is, he says, the absence of a causa in the technical sense. The specific criteria of unjustified enrichment in other ways, he says, legal scholarship has up to now, that is in 1934 when he's writing, not identified. But he adds, important for what we're saying today, he adds the concept of the absence of a legal ground does not prove to be effective in this instance. That is in the instance of enrichment in other ways. Now, let me consider now, first of all, the absence of legal ground and positive reasons for restitution in the context of transfer, and then in the context of enrichment in other ways. Now, enrichment by transfer. In Germany, paragraph 812 BGB decrees that someone who receives something as a result of a performance without legal ground is under a duty to make restitution to him. Now, the performance will be without legal ground, and the Leistungskondition will be applicable when a transfer of wealth is made by the transferor to the recipient with a specific legal relationship in mind, and the relationship that the transferor has in mind does not exist, or is invalid, or cannot form the basis of that specific transfer. Now, it is true that in this situation, the notion of without legal ground does most of the work, but a number of additional factors also play a role. That is clear from the reading of the whole section applying to unjustified enrichment. So just one of many examples. In terms of the evolving par delictum rule, which is framed as a restriction on the condictio turpem vel in justum causam, but is held to apply to all the condictiones, a number of considerations other than the mere absence of a legal ground play a role in determining whether the transfer must be reversed. And the point is this, really, that to describe without legal ground in German law entails what the anthropologist Clifford Geertz has termed a thick description, namely that one takes account of a multiplicity of complex conceptual structures, many of them superimposed upon or knotted into each other. And the same is true of French law. Eric de Scheermaker points out that it is often assumed that French law is firmly in the sine casa camp of the civilian tradition, as underlined by Article 1303 of the Code Civil, which states enrichment is unjustified if it does not proceed from the fulfillment of an obligation of the impoverished person, nor from his intention to donate. So de Scheermaker says, yes, on the in one sense, it is of course true that French law is in the sine casa camp. The claim in unjustified enrichment expressly relies on legal basis for the retention of the benefit and makes no explicit use of English-style unjust factors. But, he says, this observation must be seriously nuanced for at least two reasons. And the first is that at the heart of the law of unjust enrichment, is occupied by the doctrine of recovery of undue payments, even though, of course, technically it is an obligation separate from an obligation based on unjustified enrichment. So it says the recovery of undue payment is at the heart of matters, where liability revolves explicitly or implicitly around the unjust factors of mistake and duress, rightly understood as a mechanism to restore benefits transferred because the claimant believed he was obliged to perform an obligation that did not in fact exist. Error is inherent in the claimant's cause of action, and this is the very reason why it does not have to be specifically pleaded. Now, in Scots and South African law, it's even more explicit than it is in German and French law, that the absence of legal ground is a necessary but not a sufficient ground to reverse a transfer. The common denominator of transfers is that they all involve the flow of wealth from the transferor to the recipient. And for such a flow to be recognized, there must be a legal ground in the narrow sense. And that is why absence of legal ground is a central concern in the context of transfers, even though it is not the only concern. So much then for enrichment by transfers. Coming then to enrichment in other ways. When one turns to enrichment in other ways, it quickly becomes clear that the absence of a legal ground cannot fulfill the same role as an enrichment by transfer. Enrichment in this category, it does not necessarily occur through a transfer of wealth, which would require a legal ground to be effective. In the case of enrichment by transfer, the point of departure of the civilian approach is that the enrichment will be disapproved of, will be unjustified, if there isn't a legal basis for the transfer. Additional reasons will sometimes be necessary to render it indubitably without legal ground, while in other cases, additional reasons may prevent a transfer without legal ground from being branded as unjustified. But that the lack of a legal basis in principle renders the enrichment unjustified is the point of departure. On the other hand, when it comes to enrichment in other ways, positive reasons play a far more important part in the decision whether the law will disapprove of the enrichment. And here, civilian systems, in a part of the law that is not part of the law of enrichment in the common law, embraces positive reasons. For instance, in instances where that are very well known in English enrichment discussions and also mentioned by van der Linden, just to mention two examples, the notion of absence of legal ground is not very helpful. So take, for instance, a case where, the well-known case where authorities divert a road with the result that the defendant's house appreciates in value and the plaintiff's house diminishes. Or the well-known Rising Heat case where the defendant lives above the plaintiff's apartment and the latter heats up her flat to such a degree that the defendant saves money on heating costs. Now, anyone who asks whether the defendant is liable on the basis of unjustified enrichment in these cases will not get very far towards answering the question by relying on the sine causa approach. Both these instances have in common that the absence of a legal ground does not lead to the automatic conclusion that the enrichment is unjustified. And as van der Linden also says, a satisfactory theory must be able to tell us both why enrichment is reversed in certain circumstances and when it is not reversed, why not? So why does the sine causa not work here? Well, it doesn't work because in its nature, it is adapted as a result of its origin in the context of the Roman condictiones to deal with instances of enrichment that flow from a transfer of wealth or instances that can be equated with the transfer of wealth. So if one accepts that unjustified enrichment can exist beyond enrichment by transfer, as German and Scots and South African law undoubtedly does, then one needs a different way of determining whether the enrichment is unjustified, because beyond instances of a transfer of wealth, the negative criterion of absence of a justificatory ground simply does not work. Now, as Niall himself has remarked in his book, quoting Sonja Meier, there is a widely held view that the rules on recompense for improvements do not entirely fit the enrichment without legal ground model. Now, in such instances, one needs positive reasons to brand the enrichment as unjustified. For instance, in the case of imposed enrichment, in the form of improvement of the property of another, those legal systems that recognize liability of this kind all insist on specific positive criteria that have to be shown to exist for the enrichment to be labeled as unjustified. In the same way, in instances of enrichment by interference, for instance, German law has developed the concept of attribution to distinguish between instances where that give rise to enrichment claims and those that do not. And specific positive criteria have been developed over time to determine which gains the legal order attributes to the holder of a right and which not, and where it does, of course, the gain constitutes unjustified enrichment. Now, as Niall once again shows in his book, since the 1990s, he says, several authors in Scotland have worked towards the development on the basis of Scottish sources of such a theory aided by comparative law. So that is work in progress. So to conclude, in the same way that the common law's ongoing reception, we might call it, as Helen has done, of the notion of absence of legal ground and also of the Wilberg von Kammerer typology, as this reception draws on these concepts without importing the whole doctrinal baggage that goes with them in their system of origin, so surfacing the role of positive reasons for imposing enrichment liability in civilian systems does not mean and cannot mean simply transplanting the common law system. The view that the concepts of without legal ground and reasons for restitution both have a role to play is gaining ground. Thus, Lionel Smith has remarked that perhaps inevitably every legal system can and does mix the two approaches. Eric de Schemacher agrees that probably all systems rely on both reasons for restitution and reasons for retention, and remarks that it is certainly true of French law. The fact that the debate between Jacques du Plessis and Helen Scott in 2014 had such an immediate impact everywhere demonstrates, I think, very forcefully that it is increasingly realized that both notions have a role to play. That's why people are so interested in the debate about them. And that the questions are now more about emphasis of the one or the other in particular circumstances, while understanding that adoption needs also, in Jacques' words, to take account of fit into a legal system, and also, of course, for systems to better understand themselves. And all of these things, I think, were lifted out also by Birke Hector in her recent chapter in the Handbook on Unjust Enrichment and Restitution. So I want to end, if Niall will forgive me, by saying that the 1,000 pages of text in Niall's book is, to me, going through them, one of the best illustrations that both the absence of legal ground and the reasons for reversing unjustified enrichment have a role to play. Thank you very much.
Thank you, Danie. A suitably challenging note on which to bring the formal part of the proceedings to a close, very elegantly and clearly expressed, as indeed was the case with all our speakers. So thank you to them all. The point we now reach is that where the audience has the opportunity to have its say. I wonder if I could invite the speakers to switch on their cameras for this purpose, to allow me to draw attention to them when the questions are asked. If people want to ask questions by way of the showing of hand function on the system or by typing them into the chat, either will do. I am keeping an eye on things all around. So may we have the first question, or is the chairman going to have to abuse his privilege and ask the first? Well, I'll ask the first, given that we've got relatively limited time, and this should get us going. A thought that struck me when Jacques was speaking in particular, but it arose across perhaps all of the papers, but it's the specific problem of the unenforceable contract. And if I understood, Jacques, you correctly, you think that when a contract is unenforceable, an enrichment claim does not arise. Now, I think Sonja did not address the specific instance of the unenforceable contract, but for what it's worth, I have always thought that one of the circumstances in which Scots law would allow an enrichment claim was when a contract was unenforceable. Unenforceable in the sense sometimes of its illegality, but also with regard to the contract that is terminated for breach or where a party has failed to perform. And we, for centuries, have had our principle of mutuality of contract in these circumstances, which says that a party in breach cannot enforce the contract. It doesn't matter whether the contract's been terminated or not, although often in the cases there has been at least an attempt to do so. I wondered, Jacques and Sonja, whether you would like to comment on that particular question of unenforceability. because it being unenforceable, it's more or less equivalent to being void.
Yeah. So, I mean, the first thing is I briefly said in passing, when you engage in a comparative analysis, you have to be incredibly careful because exactly of what you've said now. So from our perspective, it's clear that the contrast is between void, and you might say void and unenforceable, but that's almost, superfluous. Whereas the alternative is then valid but unenforceable, or at least valid, but yes, exactly, valid but unenforceable. And then, of course, voidability also looms there, and Sonja referred to that. So the short answer is that, of course, it will depend on the system how the words are used. I was just trying to make the point that it would contribute to clarity if one were to talk about unenforceability, at least to then indicate whether or not you still regard the contract as being valid, because I don't see how enrichment claims could arise when you have a valid legal ground for whatever transfers have been rendered. Now, that might make less sense in other systems where unenforceable has different meanings, but that was the conceptual sort of point of departure, which I thought would be the simplest. But obviously, I mean, historically, it's a bit of a mess. That one should really accept.
Sonja?
Yeah, I agree with Jacques, and I would add this is a question of what you understand or what you mean by unenforceability. You could say in German law, for example, or in English law, some informal contracts or formal contracts lacking form are merely unenforceable, and that means you cannot go to court. But if you performed under these contracts, you cannot recover, and this is a result, which is this is just the result what we want when we say unenforceable contract, at least in German law and in English law. It's different if the contract is void, at least in German law. Then the base is away. We don't want we want recovery. This is meant by void contract. Yeah. So and a terminated contract, a contract terminated for breach, for example, is, I mean, it's not void and it's not unenforceable in that sense, which I would use. It's a contract where the specific obligation is usually gone in an untechnical way because there's no counter performance and there was a rescission for breach, and so you can recover your performance. That is what you want. And I would not say that it's an unenforceable contract in that sense.
Thank you. We'll speed on to Duncan Sheehan, who has been patiently holding his hand in the air for his question. Duncan.
Okay, thank you to you all for that. It's very interesting. Maybe this is a big question for 6 minutes to 5, but while I was listening to Danie's presentation, and I think this might be a question for any of the South Africans and not just for him, I wondered to what extent, from a South African / Scots perspective, you thought in absence of basis had a will, even if disguised, in the common law and just factors approach. I say it might be a big question for 5 to 5.
I'm sorry. I think my the audio isn't very good, so I did not. I couldn't probably catch that sorry about that. Can you just?
I'll tell you what. I can type it into the chat, and then you can. Okay.
Okay. Any other questions?
Okay, let me go to the.
Apologies for the typos.
No problem. our speakers all see this question. I wondered whether, from a South African perspective, absence of basis seemed to have a role in the common law unjust factors approach.
Sonja.
So do you mean with common law, English common law, or Scottish or South African common law?
Well, absence of consideration, those sort of things, failure of consideration, that seems to link up to some extent with absence of some basis in the narrow sense. So there would be these, but I mean, that has been commented upon, those sort of specific points of interaction.
Danie, I think you're muted. You're muted, Danie. The classic.
Sorry about that. So this is a question I think that one must not be too forward in answering. Whether so I think it's one of those very difficult questions, Duncan. But I think the frequency with which absence of basis is mentioned in common law literature nowadays, and of course, everyone has a different view of where absence of basis might come in. But again, it is not, I think, the absence of basis in exactly the same way in which it is operative in German law or French law or South African or Scots law that one is talking about, but whether a notion of absence of basis has a role to enhance a system where the first approach is to look for a reason why enrichment has to be returned. In other words, where one is in a situation where where it is assumed that enrichment, as it were, stays where it is, unless one can make that positive reason. And then, I would imagine that the way that English law has developed, the common law has developed generally, that still being the point of departure, the absence of basis will have a different supplementary role than the very central role that it has in civilian systems in transfer cases.
Helen Scott, I think, wants to contribute to this discussion. So Helen, please go ahead.
I just realized I've actually labeled William Swadling, so thanks for the clarification. Yeah, I mean, I think the problem is there are not a lot of cases where you can test the law. As we all know, that the approaches tend to produce the same outcomes on the same fact. But I mean, I think the difficulty is in English law, it's obvious that the presence of a valid obligation is a bar to a successful claim. The question is that a mere defense to a cause of action which it can be made out without reference to the absence of basis concept, or is the absence of a valid obligation or other basis constitutive of the cause of action, which would seem to be the position in South African law or Scottish law or German law. So we all know that there is a defense of good consideration, or whatever you want to call it, and that's acknowledged in many of the secondary works, but also in the cases. The question is the absence of such a legal ground the cause of action? I mean, if we were having this conversation 20 years ago, just after Kleinwort Benson, we might say that view was in the ascendant, and that's one reason that Peter Bergs gave for his new thesis in 2003. But I'm not sure that view is quite as easy to defend now. And the reason I say that is because it seems to me that there are these two decisions of the House of Lords or the Supreme Court in England, which are not compatible with the idea that the absence of basis is the cause of action. And the first of those is Deutsche Morgen Grenfell, where liability seems to, or restitution seems to be awarded in the teeth of a valid ground. And the second is one of the recent iterations of the FRI litigation in 2020. And some of you will have heard me make this argument in the context of Lionel's seminar. But it seems to me that that case is difficult to reconcile with an absence of basis view for reasons that I'm not going to reiterate now. So just as a matter of positive law in this country, I think it's hard to make the argument that this is a system which is covertly operating an absence of basis approach. What that means for South African law, which was Duncan's question, I think, I'm not sure, or maybe that was Duncan's question. Sorry, I think I strayed slightly from the path in response to Danie's question. But as I say, I think it depends. I think now we have to accept that it's quite hard to make that argument as a matter of positive law. Thanks, Hector.
Thanks, Helen. There's a question in the chat from one of my students, so I'm particularly keen to hear what the answer to this one might be. He's saying, would you consider the absence of basis from a Scots law perspective as being unified due to the difficulties of applying the condictiones outside of conferral or transfer cases? Now, I think what I would put in there, rather than due to, despite the difficulties of applying the condictiones outside of conferral cases. I mean, I think this relates perhaps to Danie's observations as much as anybody's, but it's an open question for all four contributors. Is it a difficulty for seeing the Scots law of unjustified enrichment as somehow unified by the absence of basis idea that condictiones don't apply outside the transfer case with any ease?
Well, in the first place, what I would like to say is, of course, the law of unjustified enrichment is, of course, as is very clearly shown in Niall's book, deals with, one might say, three large different areas. And I think that one can make the argument that there is some form of unity that can be read into, say, enrichment by transfer in the context of absence of legal ground, but that really can't carry through to the other areas of imposed enrichment and enrichment as a result of interference. So it is a similar question in South African law as well, is how unified a concept is that. And I think that in the end, the concept itself will always have different meanings in different situations. I think that is a very important aspect, that it is a concept that is always in need of a deeper description in wherever it is. So there are always aspects of it that are present in most or all of the different cases, but in each specific instance of enrichment that has developed both in Scots law and South African law, there are specific elements pertaining to without legal ground that are only relevant in that particular factual situation. So I think the concept itself is a helpful as in thinking clearly about enrichment, but again, the devil is in the detail.
If I may add to that,
Jack,
Danie,
yes, I could see you were looking serious, so off you go.
Yeah. So, I mean, we haven't really touched on it quite important development in South African law, that our courts are becoming, I suppose, like some of the people who've tuned in, rather impatient with all the focus on the detail of condictiones and their specific requirements and so forth, and are increasingly, and this might not be that welcome news to an English audience, increasingly looking to these general requirements to guide them. And Helen made a remark about the, our sort of us being quite strongly wedded still to the idea of, for example, error being a requirement of the condictio in debiti, but there's a, to her at least, I think it should be quite a disturbing recent case of the Supreme Court of Appeal, where it's clearly a condictio in debiti situation, an undue transfer of payments which somebody thought she had to make in terms of some pension fund. She reclaimed it. And it was just said, these are the general requirements of enrichment liability. One of them is sine causa. These payments are sine causa. Not a word was said about error. Nobody asked whether she was mistaken, why she was mistaken. And this is not some low court judgment. This is the Supreme Court of Appeal. It's Malcolm Wallace, one of our most eminent judges. So strange things are happening here. Having said that, I mean, the sort of granular detail that you get in Niall's book, I mean, even if you don't like the language of the condictiones, even if you don't particularly care for how the material is arranged, you can't just simply now invent broad interpretations of these general requirements. They will have to be anchored in the case law, and if necessary, they would have to be developed here. Thank you.
Sonja, are you wanting to add anything? No. Well, I think we should probably begin to wrap the proceedings up. I, for my sins, am being assailed by further technological difficulties in the form of my grandchildren. I do see one more hand, another of my students. So Tanya, would you like to ask your question?
Hello. I did put it in the chat, but I had a subsequent question to that. But if you guys are
yes, I see it.
I think my second question will be more helpful with my assignment, because I was just going to directly ask, like, to what extent do you and this is open to the floor, do you believe that the Scots law of unjustified enrichment is unified using comparative law examples? Because I'm kind of veering towards the third way that Danie was speaking about, because I kind of like the idea that it meets in the middle. It's characteristic of the civilian system, but it's a common law based system. I don't know if I'm making sense, but I just thought I'd ask the question directly. I'll pop it in the chat as well, just in case anyone wants to read it.
It's okay. I think I can see the first questions there. But again, would any of the speakers like to respond? Perhaps Danie again.
I'm just reading the question now, so I'm sorry, the sound isn't coming through very well in my computer. That's why I'm battling to hear the questions. So thank you very much for typing them in.
Maybe I can say something in the meanwhile.
Yeah.
Just it's in particular to your first question. I'm not sure why Germany has been criticized for its wide scope being overgeneral. I'm not sure that German law of unjustified enrichment is too overgeneral. I think everywhere we have this category of enrichment by transfer or by performance, and this is a special compartment. And in the other compartments, German law, as Danie said, does not work abstractly with the concept of lack of legal cause or lack of legal cause. But we have groups of cases where we develop criteria for determining whether an enrichment claim lies or not. And in this respect, we move from case to case, even in Germany. And you don't find the conditions for an unjustified enrichment claim in the civil code. You can't find it. You have to look into the case law and into the books, like England, Scotland, South Africa. And nobody would no court would say, well, there is no legal cause, so there is a claim in unjustified enrichment. No, they say, well, here the defender was mala fide, or here that was not reasonable, or here the person has to be protected, or anything like that. So I think there is no material difference between our legal systems.
Thank you.
Yes, well, so I can add to that, just that, or reiterate the statement that I referred to earlier, that Sonja said to me, it's not a third way, it is what civil law systems do, you know. So I think the important thing for systems like Scots law and South African law is that perhaps there has been, you might call it a hesitancy or uncertainty in actually just bringing out the actual positive reasons where why enrichment should be allowed in certain circumstances. And you know, they are sometimes all hidden in very convoluted forms of redress. So in other words, Jacques has, for instance, commented in something that he's written, that when one looks at why and exactly when improvements to another's property should be the subject of recompense, is very difficult to formulate the rules. But it doesn't mean that they can't be formulated, but it is very difficult to do it. So I think going forward, and for someone who is looking at you know, how should the law develop, I think again that surfacing consciously of those reasons, searching for the explanations, searching for how to actually put into words, into a comprehensible way, why one is actually labeling this as unjustified enrichment is the way forward. And as Sonja said, that is going to be very much context bound, because it depends on where you are doing it. And that shows again the relevance of reasons, and that concentration on positive reasons why one should be making a restitution in a particular instance.
Thank you. I think we should probably start to wrap up. I would just like to make one comment in relation to this discussion, because it was something that was in Niall's video, which unfortunately we didn't quite get to hear. But he makes the important point, I think, in contrasting the Scots and English position specifically, that the Scots have had their categories, including improvements and interference cases, for centuries, and that what the Wilberg von Keimerer typology did was to provide a way in which that could be better understood and seen, so that you could see this is the Scots law of unjustified enrichment. This is what it comprises. Whereas in England, the processes of development have been that the general principle of unjust enrichment is recognized very late, and it doesn't encompass some of these cases, the improvement cases, the interference cases, and so on. They are already established in English law, if they have a remedy at all, as based in tort or some other obligation than enrichment. So that the argument in Scotland, Niall suggests, is different from the argument in England. In other words, Niall is not looking to discuss whether there's a small enrichment or a big enrichment. He says this is the Scots law of enrichment. It includes these cases, and the German typology gives us a way in which we can understand that and build upon it for the future. So I think that connects quite importantly to some of the things that have just been said in the answers to Tanya's very interesting question. Can I begin to shut the show down? I was confronted about half an hour ago with a further technological difficulty in that my grandsons arrived. And so I've had my microphone off quite a lot during the last 40 minutes or so. I need to go out, I think, and quiet them off once more. But before I do that, can I just thank our speakers and Neil for what they have put into this seminar. I hope the link will enable everyone to watch what Neil's statement of his position is, and it will doubtless develop in the ongoing work of the future. But it has been absolutely wonderful to have such a distinguished cast of speakers saying so many interesting things in response to Neil's work, and to have such a large audience watching it and taking part in this very important debate. So I'll finish at that point. Thank you everybody for attending, and the proceedings may appear in the Edinburgh Law Review in the next few months, so watch out for that. Okay, thank you very much everybody. Bye-bye.